good evening, everyone. Good evening, Your Excellencies, distinguished guests, including our special guests from the United Kingdom, the Right Honourable the Lord Thomas of Cwmgiedd, Lord Chief Justice of England and Wales, and Lady Elizabeth Ann Thomas, his wife. Ladies and gentlemen, members of the DIFC legal community, it's both a pleasure and a privilege to welcome you to the first of the Academy of Law's lecture series for 2016. I'd like to thank Fulken & Associates for hosting us today in their brand new, and wasn't it lovely to smell the paint on the way in? They're absolutely brand new, and I think it's fair to say, Al, this is your first sort of event of this nature here. So we're extremely grateful to Fulken for letting us use their state-of-the-art auditorium, which is full of so many familiar faces, and it's lovely to see you. And for those I haven't said it to already, Happy New Year. I'd like to invite to the lectern Chief Justice Michael Hwang, who you all know very well, so I don't need to tell you that he's the Chief Justice of the Court, that he was appointed Chief Justice in 2010, having served as Deputy Chief Justice since 2005. And nor do I need to tell you that in 2014 he was appointed the head of the Dispute Resolution Authority here in the DIFC, which includes the Academy of Law, which is your host this evening. And so because I don't need to tell you those things, I won't. So without further ado, Chief Justice.
Good evening, everyone. Tonight I'm going to share with you our plans for the year ahead. I have quite a long paper here, mainly because the detail is necessary when we have my presentation printed and uploaded onto our website. But for this evening, the star of the evening is the Lord Chief Justice, so I'll try and cut my presentation to the bare essentials. Let's start with a goodbye first, which is my expression of gratitude and the gratitude of my fellow judges and all who have worked with Sir John Chadwick for the valuable contributions he has made during his time as Deputy Chief Justice of our courts. On the 20th of January this year, Sir John retired from his role as Deputy Chief Justice, but he remains with us as a judge of the DIFC courts and a member of the Dubai World Tribunal for his ongoing cases. I would also like to record our deep debt of gratitude to him for all his contributions to the courts and the tribunal, and hopefully we will be able to express our appreciation to him in person when he attends our gala dinner, which is fixed for Thursday, the 20th of October 2016, so key that date in right now. I have recommended the name of a successor to Sir John to His Highness the Ruler, and look forward to being able to announce that successor shortly. Although we have been operating as a court for over 7 years and have achieved an unforeseen measure of success and recognition, we are still in the process of capacity building, and there's much more to do. As a commitment for 2016, we will continue to build on the trust and confidence of the international legal and business communities by developing the strengths of our uniquely international and experienced bench of judges to deal with the most complex and high-value transnational disputes. We are also looking to strengthen our bench by the appointment of another overseas judge to fill Sir John's place, and I hope to announce that appointment shortly. With regard to our local Emirati judges, we are currently putting into place a plan for enhanced responsibilities to be assumed by them, and I will also announce that plan together with the announcement of the new Deputy Chief Justice. Let me now say a few words about case management, and I'm going to overwhelm you with statistics. I'm pleased to report that in 2015, the average value per CFI claim has risen by 149% increase year on year. The total value of claims and counterclaims filed in the CFI showed a 188% increase from the previous year. There were 79 CFI arbitration and enforcement claims, showing an 88% increase in claims filed from 2014. And this is despite our increase in the jurisdiction of the Small Claims Tribunal. The Small Claims Tribunal itself showed a 186% increase for 2015. Moving on, the full statistics will be in the uploaded version on our website, but let me just make one important point in the way that we are handling our future case management. We will endeavor to arrange hearings according to the availability of parties' legal representatives, but not at the expense of actively progressing the cases entrusted to us. The profession needs to appreciate the tension between allowing reasonable accommodation of council's calendars and allowing long delays because the council chosen are too busy to fit in a hearing within a reasonable time. There are other matters of specific interest which I have asked to be considered this year. The first is that our provisions regarding leave to appeal be reconsidered to ensure that those rules remain up to date and supportive of efficient, fair and transparent best practices. And I expect any changes in that area will be the subject of public consultation. The second is that we will explore fast-track schemes and shorter trial schemes, which will be explained by Lord Chief Justice Thomas in his lecture, in an attempt to provide shorter, more flexible and streamlined litigation. The next point I want to draw your attention to is that I intend to review trends in relation to costs litigation by producing an analysis of all costs awarded by DIFC courts and to share the details with you. This means that we are preparing a database of precedents of costs awards, which will be publicly available online so that practitioners can easily study them and cite them as authorities when arguing assessment applications. The next area of interest is in arbitration. Given the sharp increase in arbitration cases in our CFI over the last couple of years, I have suggested that an analysis be made of all our arbitration cases to show the jurisprudential importance of our judgments and the contributions the DIFC courts have made to international arbitration law. Next, we now have a new item on the agenda of the courts, which is to handle probate matters. Following the establishment of the DIFC Wills and Probate Registry, I will be exploring ways to manage the increased workload in terms of administrative tasks, such as issuing the necessary court orders, as well as dealing with the applications and cases which flow from this service. The last point of interest is that following discussions with our General Counsel Forum and some of our Users Committee members, I've asked that our court fees be reviewed again to ensure that they strike a balance between the economic realities of running an international commercial court and delivering a good value service to our court users and their clients. You will know that our new fees were introduced last year with an ad valorem cap of $130,000 US. Following the change in our fee structure, members of the legal community have suggested further refinement, including the reduction of fees for relatively straightforward processes. Now, this is something I will be reviewing in the early part of this year. Let me move on to say a few words about connectivity. And of course, at the heart of this is our movement to sign a number of memoranda of guidance with sister and brother courts around the world relating to the enforcement of judgments of one court in the other court. You will have read from reports that last year we signed 2 MOGs with the Supreme Court of Singapore, as well as an MOG with the US District Court for the Southern District of New York. In August, we also signed memoranda with the Supreme Court of Kazakhstan, which is the first signing with a civil law country. But that was made easier by the fact that the UAE and Kazakhstan has a treaty for mutual enforcement of judgments. But then in November, we signed with the Supreme Court of Korea, which is the first civil law country with which we have connected, with whom the UAE has no treaty for reciprocal enforcement of civil and commercial decisions. Now, these last signings have encouraged us to focus our attention on signing our next MOGs with civil law jurisdictions after having researched how straightforward the enforcement processes are in each civil law country of interest. So we will have to progress on a country-by-country basis. We place great importance on our engagement with the legal community through the standing committees that we have in the Court Users Committee, the Rules Subcommittee, and General Counsel Forum. And we will continue to engage with this community, and now relying also on the DIFC Court's Academy of Law. Turning to our partnerships with the local legal community, we intend to work closely with the Academy of Law, which, as many of you will know, has assumed responsibility for legal and advocacy training, as well as other activities such as publications of rules and judgments, lawyer registrations, code of conduct disputes, and organizing events such as the DIFC Courts Lecture Series and the Gala Dinner, which I repeat will take place this year on the 20th of October. Lastly, I'm pleased to announce that following the hard work of a number of practitioners from some of the major Dubai-based law firms, the first edition of the Commentaries on the DIFC Laws of Contract, Damages and Remedies, Obligations, and Arbitration will shortly be released. If you will, this is somewhat like Halsbury's Laws of the DIFC. And these are just the first volumes in the series. This is, I have felt that this is a sorely needed resource for our practitioners, and we are most grateful to Clifford Chance, Clyde & Co, and Baker Botts, and together with our Assistant Registrar, Natasha Bakirci, for their commitment to undertake the task of writing the commentaries, and now under the supervision of David Gallo of the Academy of Law, which has taken responsibility for this project, and also with the assistance of Professor Harold Costa from the University of Dubai. More volumes with the assistance of other law firms are in the planning stage. I'll turn now to service excellence. Now, under this heading, I want to draw your attention or remind you of our long association with the International Association for Court Excellence, IACA. And of that organization, our judge, His Excellency Justice Ali Al-Madani, is chairman for the Middle East Board, and our registrar, Mark Beer, is regional vice president. This year, there is the annual conference of IACA in The Hague in May, and at that time, Mark Beer will assume the office of president-elect of IACA. So my congratulations to him. And again, we put ourselves on the world map. Next, I want to say a few words about innovation. Over the years, we have successfully delivered a number of world firsts and placed innovation at the heart of our operational model. We were the first in the world accredited to the International Standards for Service Excellence, TISSE. We were the first Arab country to appoint a female judge in the UAE. We launched the country's first pro bono scheme, the first small claims tribunal, and the first code of conduct for lawyers. And we were the first Dubai government entity to receive the 5-star award under the country's Service Excellence program. In line with the UAE's Year of Innovation, in February last year, we introduced a first-of-its-kind mechanism, allowing parties opting into the jurisdiction of the DIFC courts to also refer their final judgments for enforcement through the DIFC LCIA Arbitration Center. This is known as the DIFC Court's Judgment Arbitration Protocol. And if this protocol is adopted by the parties, it enables a judgment creditor to have an additional remedy for enforcing its judgment by referring a dispute between the parties about payment of the judgment sum to arbitration, thereby attracting the remedies available for the enforcement of arbitration awards under the New York Convention. This development is another example of our courts taking the lead to find new ways of furthering the enforceability of our judgments and increasing the speed at which commercial disputes are settled. We've also, in the first month of this year, issued 3 new practice directions. So we were working hard over Christmas. The first direction reminds practitioners that lawyers representing litigants should not normally file witness statements on matters of fact, as they are then treated as witnesses, which is not permitted by our mandatory code of conduct. It also has limited evidential value for lack of first-hand knowledge. The direction also advises that lawyers who purport to act as legal experts and file expert reports on matters of foreign law will be regarded as having lack of independence and their reports discounted for this reason. The second direction restricts the length of skeleton arguments and pleadings in the CFI to 25 pages for trials, 15 pages for interlocutory applications, and 35 pages for appeals. The third direction advises that cases where the courts have directed anonymization of parties' names will be referred to by given names instead of alphabets to make it easier for lawyers and judges to remember their names. This new system will be implemented with retrospective effect, so that all cases which were previously reported using alphabets in lieu of names will now be retitled in accordance with this direction. The rules of the DIFC courts already support the use of alternative dispute resolution, and for this year I wish to explore further opportunities to encourage alternative dispute resolution to support settlement of disputes. Now that we have under the DIFC Dispute Resolution Authority, the DIFC LCIA Arbitration Center, which plans also to handle mediation of commercial disputes. The one sour note that I want to sound in this speech is the worrying trend in the way in which certain law firms and counsel are pursuing their cases in our courts, which gives sometimes the strong impression that their clients are bent on derailing the court process by guerrilla tactics of delay and attrition rather than fighting the case on its merits. I am the author of the phrase arbitration guerrillas, which is now freely used in the vocabulary of arbitration, and I think I know guerrilla tactics when I see them. And I am instructing our judges to be firm and robust in dealing with any such tactics. Let me end on a high note. Last year in 2015, the DIFC courts were selected by the National Bank of Kazakhstan to consult on the wide range of issues that need to be considered and steps that need to be taken as they establish an internationally respected commercial court and arbitration center at the planned Astana International Financial Center. As part of our 5-year plan, we aspire to leverage on the status of our courts as an established center of legal excellence and provide consultancy directly or indirectly for other jurisdictions and systems across the world, showcasing the DIFC as an exemplar to be followed. Here ends my report. I now have the happy task of introducing our guest speaker for this evening, Lord Chief Justice John Thomas, who is an old friend, and we swapped notes this earlier today and agreed that we had first met way back in the 1980s, when both of us were active counsel at the bar, I in Singapore and he in London, and he came briefed by my opponent to be the leader in a case in Singapore. We also happen to be associated with the same chambers, as was Sir Anthony Evidence and Sir Anthony Coleman. In fact, I'm not quite sure why Sir David Steele is actually part of our bench. I think he's our token non-Essex Court Chambers member. We're delighted tonight to be joined by England and Wales' most senior judge. Lord Thomas is here with us, and his topic is commercial justice and the global village, a subject that resonates strongly here in Dubai and is particularly apt this evening as we listen to his lecture in the Gate Village. before I hand over to tonight's guest, allow me to tell you a little bit about Lord Thomas's remarkable career. He was educated at Trinity Hall, Cambridge. He went on to become a Commonwealth Fellow at the University of Chicago Law School. He practiced at the Commercial Bar in London from 1971 and became a Queen's Counsel in 1984, before being a judge of the High Court in England and Wales in 1996. Lord Thomas was the judge in charge of the Commercial Court in London from 2002 to 2003, after which he was appointed as a Lord Justice of Appeal. So he sat in the Court of Appeal. And then from 2011 to 2013, he was president of the Queen's Bench Division, which is the period that we signed our MOG. And at the end of 2013, he was appointed Lord Chief Justice of England and Wales. When he was the president of the Queen's Bench Division, from 2011 to 2013, he approved the signing of the now famous MOG between the English Commercial Court and the DIFC courts in 2013, where we set out in this MOG the common principles for the enforcement of our judgment in England and Wales and vice versa. That MOG became our passport to engaging with other jurisdictions and persuading them to sign similar MOGs with us on the basis that the English Commercial Court's agreement to this MOG meant that those principles could readily be adopted by other common law countries. So we owe him a huge personal debt of gratitude for setting us on the path to international recognition. It is now my distinct pleasure to welcome to the podium this evening's guest, the Right Honourable Lord Chief Justice John Thomas.
Chief Justice, Your Excellencies, ladies and gentlemen, I'm extremely grateful to the Academy of Law and to the DIFC Court for inviting me here this evening. I've had an opportunity of both meeting the Academy and seeing the Court and discussing the way in which it works. But what I wanted to talk about tonight was not this particular court, but the way in which courts, and in particular those that deal with commerce and business across the world, should face the effect of what is in effect a huge revolution that is being brought about by the use of digital technology and the huge changes that are occurring. I have no doubt at all that many years ago it was a visionary, Marshall McLuhan, who thought of the coming of the current age. He predicted the global village. He predicted in what we would then now describe as the analog age, the fact that we would have something like the internet. He understood the potential that that would bring. He predicted the idea that computers would become research and communication instruments which could enhance retrieval, obsolesce mass library organization, retrieve the individual's encyclopedic function, and flip into a private line to speedily tailored data of a saleable kind. He even suggested that people would surf this newly developing medium. And I think it takes someone as remarkable as that to foresee change of the magnitude I think now we are, for the first time, properly appreciate. Because the internet has not simply provided a means for buying almost everything, but it has now, I think we can see, fundamentally altered the way in which business is done and the way in which the world has contracted into the small village that it now is. We have now to address a huge number of problems because the world is now very different to the world that, for example, I grew up with, but looking at some of the younger people in the room, even the world they grew up in. Now, if I take the legal profession as an example of the change, it is quite clear that what has facilitated the huge growth in offshoring and nearshoring work, if I may use those terms, has been the digital age. but it's also facilitated enormously the growth of law firms across the jurisdictions of the world. Whereas I recall global law firms, we thought of them as such at the time, with maybe an office in Paris or possibly an office in Singapore, they would never be considered as a global law firm today. We have therefore seen the transformation, I think as possibly The Economist described it in 2010, not inaccurately, as what would happen to the talented graduate. He would, if he came from one of the world's top law schools, expect a life of globe-trotting. A single month's work could include writing the small print on a Saudi investment in Africa, helping an Indonesian law firm to market its shares in New York, and writing a contract under English law between two companies in Russia. The detail may have changed, but the idea is the same. And I think the way in which the profession has developed must show the way in which we move for the future. And what I really wanted to talk about tonight was how do we respond to that? Because lawyers are, as I've just illustrated, an illustration or part of the story. But there is much more. Strong and effective markets rest on a firm commitment to law and the rule of law. This is as true of local and national markets as it is of transnational and international ones. Many reports of the World Bank make this very, very clear. And although it is, I think, sometimes tedious to reaffirm that, I make no apology for doing so. For example, most recently, the United Nations, in its General Assembly Resolution 70/1 on sustainable development, reiterated this last year, its Article 9 highlighted, among other things, the fundamental importance of good governance and the rule of law as a means of facilitating sustainable economic growth nationally and internationally. I would say, if you took the word sustainable out, it is exactly the same sentiment. Law is indispensable to the promotion of growth. Now, we all know that fundamental to the rule of law in a nation state is an effective justice system. It's constituted, as we have all, I think, come to appreciate, accessible courts presided over an independent and highly qualified judiciary, delivering quality justice and commanding public confidence. And we understand its fundamental importance for a number of different reasons. It underpins the operation of the markets and commerce. It enables contracts to be enforced and debts paid through a just and fair process. It provides a sound framework for just dispute resolution, enabling businesses to resolve their disputes, if necessary, on their substantive merits. It is, in short, essential to economic prosperity, just as more traditionally, if I was addressing a different audience, one might refer to its indispensable nature in holding governments to account and ensuring that the state deals fairly with individuals. And therefore, effective courts are, we think, central to the operation of a nation state. But how do we ensure that our laws and our courts properly underpin the interconnected economies and markets of the digital age and protect and foster international trade? Now, there is, of course, a long history of the way in which the law has adapted to the needs of international commerce by the evolution of law, which has been applied internationally. It's taken very many forms. One example, particularly appropriate for one of the judges of this court, is the Lex Rodia de Jactu, the law which provided a basis for compensation for those whose cargo was jettisoned to save the ship and the remainder of the cargo. As its name implies, its origins lie in the trade of the Mediterranean in pre-Roman times. As its Latin tag implies, it was adopted into Roman law, and then in the European Middle Ages via a code named after the small island of Oloron off the coast of France, to the Admiralty Court of England, and then by international rules to form the basis of our modern law of general average. Numerous state-sponsored international conventions have similarly, but not with quite the same ancient lineage, been developed from either commonly accepted laws of merchants or for the laws of particular states. Another method has been the adoption of standard terms, either through the acceptance of the terms of a market that has won early dominance, such as some of the commodity markets in London and in New York or Chicago, or by agreement fostered by international bodies such as the ICC, for example, the Uniform Customs and Practices for Letters of Credit, or the ISDA agreements for swaps and derivatives. There can be no doubt that this will be an ongoing process. But I think that we have to pause to remember that this will be a more complicated process because consumers are now becoming part of the way in which people do business internationally. We must there, of course, look for a different regime because one is looking for a protective regime. And an example which is very recent of the thinking that is occurring in Europe is the publication on the 9th of December 2015 by the European Commission of a proposal for common terms applicable across the European to the supply of digital content. But although the provision of law has adapted to the needs of international trade, and I think will adapt now to protecting consumers internationally, the role of the courts and the legal framework for the enforcement of that law has a relatively shorter and much more difficult history. Courts, as state institutions, have historically left it to the executive and legislature to make interstate arrangements for enforcement. Some state courts have, however, developed their own case law to the end. But one of the reasons that arbitration has been such an attraction for international commerce is what is perceived as the much more robust regime provided by the New York Convention for Enforcement. However, with the advent of the global village in the digital age, and with the necessity of meeting the needs of this century, there is, I think, little doubt we need to examine if what we have put in place as this part of the global framework adequate. Now, without any doubt, such an examination is a huge topic. For example, it must now include dealing with substantive law and the means of enforcement for consumers, something people would not have thought about maybe 10, 20 years ago. I have touched on the substantive law a little earlier, but in England and Wales, as Lord Justice Briggs explains in his report, which was published in January of this year, we are considering the creation of an online court, specifically being developed to provide a means by which small consumer and other disputes can be resolved and rights enforced. Because the topic is such a vast one, I want therefore to take one small bite-sized chunk this evening. I want to look at commercial courts, and I use that as a convenient term to encompass courts whose function is exclusively dedicated to dealing with the dispute resolution relating to markets, commerce, and the rights relating to them, and consider how they can be made fit for the 21st century. In outlining some tentative suggestions, I will concentrate on the steps that could be taken to improve the legal framework for the local businesses and how commercial courts are best placed to achieve this. But first it's necessary to say a little bit about the strengths of what we already have. It is, I think, self-evident that a sound legal framework is constituted by a clear, readily accessible and understandable substantive law, procedural law that facilitates consensual settlement of disputes, and where that is not possible, speedy and just decisions by accessible courts whose judgments are readily enforceable. Although I have referred to courts as part of the legal framework, primarily concerned with the dispute resolution between the immediate parties to a dispute, that is but one of their functions. And I think sometimes we overlook the importance of their judgments in another respect. They provide the benchmark for others in the market, particularly at a time when change of the kind I described is occurring. In common law jurisdictions, they develop the law through precedent in response to market and business needs and to the changes in society. They innovate in response to innovation, but generally the common law courts do so incrementally and consistently with established principle, ensuring that the law doesn't lose its predictability. The framework therefore remains stable while meeting society's changing nature. And given the speed at which our digital village is developing and the effect such as developments are having on society and business, the role taken by commercial courts based on common law, such as the several courts which sit in the Rolls building in London and those of the Dubai International Financial Centre, which, as Chief Justice Hwang has noted, is a common law island in the civilian ocean, cannot be underestimated. They ensure that the law does not remain locked in its analogue world. Although it is right, I think, to maintain the distinction between the common law courts and the civilian courts, I think the distinction is in the beginning of a very slow process of erosion. I think this can be most clearly seen in Europe. For example, by the case law of the Court of Justice of the European Union in Luxembourg and the European Court of Justice in Strasbourg, because they have been influenced in part by the need to build a law through cases to interpret open textured treaties, and they have also been influenced more recently by those trained or educated in the common law world. And so one is beginning to see, I think, an erosion of the difference, but at the moment we are still here in a common law island. But the difference with the civilian method, I'm not sure will last all that long. But the development of the law by the courts has, however, historically been reactive. To borrow an idea from related contexts, their role has typically been that of firefighting, with fire prevention as a necessary consequence of how the firefighting exercise is carried out. Like traditional firefighters, courts wait for a dispute. One consequence of this has in general been the absence of any considered strategic reform of our court system to enable them better to sharpen the legal framework. There are, of course, notable exceptions, and the creation of the Commercial Court in London in 1895 was one of those. A problem was identified at that time in the delivery of high-quality, timely and cost-effective justice for commercial disputes. And targeted reform was enacted to rectify it. If I can again quote from Chief Justice Hwang, what has resulted is what has been arguably the most successful commercial court in the world. The importance of that success and that of other commercial courts cannot therefore be underestimated. And before we embark on change and development, we are starting from a very strong basis here in Dubai, obviously in London and elsewhere. But given the rapid changes to business and international markets resulting from the digital revolution, if such commercial courts are to continue to be successful, they must build on their strength and realise their full potential. The aim of such courts should be to ensure the legal framework is properly adapted to and responsive to the new marketplace. Courts can no longer afford to be reactive. They must think and plan strategically in order to ensure, as the Victorians did in the United Kingdom in the 1890s, that the courts will carry out their role in the rapidly developing digital world. It is, I think, in the public interest we do so. Judges have the expertise, and as I have outlined on another occasion, judges have the responsibility to carry out this role. But if this is to be done properly, what approach should be taken to realising the full potential of the commercial courts to meet the needs of the 21st century? And I'm going to take 4 topics to try and answer the question I've posed myself. The first topic I want to take is what I've entitled market-motivated but judge-led reform. First, I think we must ensure that we develop our approach and any reforms in the light of what market users consider may assist the needs of the market and commerce that is now the global village. There is, I think, singularly little point in a committee of judges designing reform according to some abstract principle and in isolation from their perception of the need for the development of the law and the modern day realities of dispute resolution, particularly cost as is now perceived to be so important by the market user. And I should stress that by the market user, I don't mean the lawyer, I don't mean the professional litigant, but I mean all those in the market in its widest sense, and those in international commerce. Judges must ascertain the needs of all with the widest possible discussion and then lead the reform. And when I say the widest possible discussion, particularly with those who are really engaged in commerce, but maybe have stood back from the courts because they haven't really liked or appreciated what they do. But I think design must also take into account two things. Primarily, and I shall come back to these in a moment, technological development and thereby the reduction in cost. I think we should also look at the considerable evolution of differing approaches to dispute resolution across the globe. And where beneficial developments are found in one court, judges should learn from that and give serious consideration to their adoption elsewhere. And can I illustrate that by the process of adoption into procedure formally of early neutral evaluation. Early neutral evaluation, or ENE, has a long history. It's possibly sensible to begin in London in the 1950s and 60s, when it was common in the relatively small communities that formed the ship chartering and insurance markets of London to take the opinion of one or two of the two or three leading practitioners of the day and settle disputes on the basis of that opinion. That did not survive long beyond the 60s. And more recently, we have seen the evolution of ENE to it becoming formalized as part of the judicial process. First, I think, in California in the 1980s, and then in the London Commercial Court and the Technology and Construction Court during the 1990s. Unlike in the US, unfortunately, its uptake as a formal part of the process was, until relatively recently, sporadic. But recognizing its utility and an increase in use in its awareness in chancery proceedings, it was confirmed to be within the general case management powers by way of amendment to the civil court rules of England and Wales very recently. And given that, I would anticipate that both parties and the court, which can now order ENE to take place, may well make greater use of it. That's one innovation, and may I return here for another innovation, which Chief Justice Hwang has mentioned earlier this evening, and that is the use of the arbitration enforcement procedure to convert a judgment into an arbitration award in the very ingenious way that has been suggested. This is, in a sense, the opposite side of a coin to what we have done occasionally in the United Kingdom, because we have, since 1972, been able to appoint a judge as an arbitrator. Unfortunately, this has been a matter which the courts have consented rarely to, simply because of the enormous pressure of the other parts of judicial business. But that is another innovation. Either turn the judgment into an arbitration award or turn the judge into an arbitrator. There is precedent in California for doing this as well. How successful it will be, I know not. But these are two really important examples of looking and saying, yes, this is the solution to a practical problem. But both might seem rather timid, I know not. But I believe that the only way forward is for courts to be bold in such developments. We have to be bold in our practical application, bold in addressing issues of principle that they might produce. But I do think that, above all, this has to be tested against what the market needs and what the market thinks will be best for the operation of the market, of international commerce, and the operation of a much tighter framework for law and the enforcement of contracts and judgments. But it does seem to me that here is a first and fertile use. Look at what the market wants, look elsewhere, and see what we can do. And the best illustration that I can come up with, and I shall come back to this on one or two occasions later, is what we have done in the financial list in London. As you know, this is a list which is uniquely part of the commercial court in London, using that term in its very specific sense, and the Chancery Division. We're keeping its operation under scrutiny, and in the result of as a result of the pilot and feedback, we may modify it. But what I do want to stress for this first point, to end this first topic, is the following. This was not done because judges decided it was a good thing to do. What we did was ask the market and gave them a whole range of possible options as to the development. We got a response back, and what we have done is really acted in response to the market. It's what the market has wanted, it is what the central regulators have wanted, and it is what the institutions have wanted. Now that's the first topic I wanted to take. Market motivated, but judge-led reform. The second thing that I think is crucial to the development is the personnel. And I think there are three groups of personnel I want to look at, pretty obvious really. Judges, the legal profession, and court administrators. Well, can I take judges first? I think that it's essential that each commercial court must be able to attract the highest quality of judge to that court. The commercial court in London, I think, is very well known for the particularly high quality of its judiciary. And confidence and trust in that judiciary, the expertise in producing judgments, is a matter of record. And one, I think, is seeing that in other commercial courts, particularly, for example, here in Dubai. But confidence and trust in the judiciary, their probity, their judgment, and the expertise is essential for each commercial court. And we must do everything we can to ensure that courts that are truly to be recognised in this way as true international commercial courts must attract the very best people. It is not an easy thing to do, but it does seem to me that it is one of the absolute essential building blocks of going forward. Secondly, what is essential to any court in the commercial world is the strength of the legal profession. And I think that the legal profession has to have two essential qualities: being innovative and being excellent. Now, if I can take the legal profession of England and Wales, and I suspect I'm addressing a lot of them here this evening, the public perception on the whole is you're a pretty conservative bunch, you're very resistant to change, and you're entirely protective of your own interests. But I don't think that's a fair picture. I think that a truly conservative profession, wanting a more comfortable life, would have remained resolutely focused on their work within their own jurisdiction. And I think the fact that one has seen the expansion of firms to overseas offices, both law firms and now barristers' chambers, show that the profession is prepared to be innovative. And this has been very good, not only for the firms concerned, but actually for the individual lawyers and their practices before other courts, because they are able to learn and spread that to which I've earlier referred, namely information about other techniques of dispute resolution. So I think that the innovation of the legal profession, again, is terribly important to the way in which we move forward. And if I can give one illustration of that kind of innovation, then it's this. And it's taken from what Lord Neuberger said in 2012. And he highlighted how one London-based international firm had introduced in the preceding year an option for its trainees to undertake an MBA as part of their vocational training. In 2012, this was to become a mandatory part of their training, and further training was to be given after their quality. Now, that does look like real innovation, but I wonder whether it's quite as innovative, and we don't need to encourage more innovation, because of course the 19th century ideal of a solicitor was a man of business. But it is an innovation which I would strongly encourage. But secondly, innovation is not enough, and one has to ensure that the profession is excellent. Because the key skill where commercial courts are concerned is that of excellence and integrity. Integrity speaks for itself, and I need say no more. But the ability to present complex cases skillfully, to assist the court in reaching the right decision within a clear legal structure, and an understanding of the markets and commerce is absolutely imperative to the sound development of the law. And it seems to me this is particularly important in a court such as this, where advocates are able to obtain rights of audience across from different jurisdictions. And you have advocates who are appearing more and more frequently in courts where there are different ways of doing things. It is, to my mind, absolutely essential that the skill in advocacy and as importantly, an understanding of the law and an understanding of the commerce must be a prerequisite of the lawyers that are allowed to be advocates in front of these courts. Because without advocacy of that quality, one is not going to be able to see the judges develop the law in the way I've explained. And one must always remember that a court publishes its judgments and they develop the law. So the role of an advocate is very, very important. And third of my topics, and last but by no means least, is the strength of the court administration. If I can put it this way, from a judge's perspective it might look like it. It's all very well buying a top-of-the-range sports car, but you mustn't skimp on the engine. A Ferrari needs a Ferrari's engine. A truly effective court requires excellence to run it. It cannot make do with first-class judges and a first-class legal profession. It needs a first-class administration. And I think in this regard, the developments here in Dubai and in Singapore, where the commercial courts are led by highly skilled and experienced registrars and supported by an excellent staff, the excellence of which I've personally seen today, they have set a benchmark. In London, in the commercial court, using that term again in its very strict sense, leadership is provided differently. It's provided by the judiciary, and particularly by the judge in charge of the court this year, Mr. Justice Blair. It's judicial leadership, but that which works with an extremely dedicated and knowledgeable complement, that provides the underpinning of the administration. Maintaining these high standards, I think, will require court staff to have the most up-to-date training, not least in the use of rapidly changing technological environment. And that this great importance of court administration being up to date, I think, is my third of my key messages in respect of the personnel you need. Then can I turn to the third area which I consider we need to look at in this process of coming to terms with the digital age and our increasingly interconnected society, and that is our processes. And I want to look at two areas very briefly. First, court rules and court technology. Now here I really do want to quote Chief Justice Han. He said, the rules of the English commercial court are generally accepted as being the most suitable set of rules to determine the trying of complex commercial cases. You would not expect me to disagree. I do not. Though, I would add, I am not at all complacent and see the ever-present need for improvement. In October of last year, in addition to the financial list, and I shall come back to a bit more about that in a moment, 2 year-long pilot schemes that are now operative in a number of courts, including the commercial court, were introduced, what we call the shorter trial procedure and the flexible trial procedure. The aim of both procedures is to do justice in commercial disputes more proportionately and cost-effectively, thus being entirely reflective of the needs of our court users, the business community, and most importantly, of disposing of disputes justly. Both schemes are optional. They're available if the parties take advantage of them. The shorter trial procedure provides for a fixed length of trial of a maximum of 4 days, with a trial to be held within 10 months of the issue of proceedings. Claims are docketed and subject to time limits to comply with procedural obligations and on disclosure and evidence. The flexible trial procedure enables the normal processes to be adapted to the parties' needs. It aims at facilitating agreement on modifications and limits to disclosure, very important these days, expert and other evidence, and equally importantly, as Chief Justice Swain has said, the length of submissions. Both forms of process are intended to provide parties and their lawyers the opportunity to adopt a form of process that best serves their needs in pursuit of judgment. And these two introductions that we have made in London, I think, are examples of the innovation that our courts must all pursue to face the new age. I think our work on the shorter trials procedure and flexible trials procedure will be effective. Commercial parties have always wanted something that provides, in the right case, a truncated trial procedure. We tried that in the period up to 1974 through the use of the interim injunction, where the judge would take a view, a first shot view of the merits. The House of Lords put a stop to that in American cyanamide, and I think it's one of my regrets that we never actually, until very recently, turned to look at a new form of truncated court-based procedure. But we've now done so. I'm reasonably confident in its success, but time will tell. But my message is not how good we are in England, no. It is actually what you've got to do is to be innovative in procedure. And the second aspect of process is technology. I have absolutely no doubt that this is going to make a huge difference to the way in which we do things. We are looking very carefully in England and Wales of trying to get rid of all interlocutory proceedings requiring people to come to court. We see no reason why this should not be done by video conferences. But we must also be bold. We must see to what extent we can overcome some of the old-fashioned restrictions on territoriality and see if you could actually do much more from a remote location. We also, I think, need to be highly innovative and think, does technology enable judges, maybe from different jurisdictions in the presence of the parties, to raise issues? I don't know. But technology is a new era for judges. No court has properly, in my view, grasped the challenge. But I have no doubt here, or back at home in London, or in Singapore and elsewhere, one will see huge changes that can be enabled through our new technology. Now, none of this will help unless we actually see there are means to an end. And it's pretty obvious what that end is. And it is to that I wish to turn. High quality justice. And I think that in this respect, we must make sure that as commercial courts develop, it's their ethos that they should be practical, not proceeding on abstract principle, but using principle to develop law that is one that will encourage and enhance prosperity and one that will ensure the international rule of law. Now, how do we do that? And I want to touch on just 2 or 3 topics. First, keeping abreast with commercial change. Now, probably the most distinguished of my predecessors was the Earl of Mansfield. And he, as you will know from the study of legal history, was the judge most responsible for the early building blocks of English commercial and insurance law. And what he did was to use special juries drawn from the market who were really experts in commerce. They'd be commercial merchants, insurance brokers, traders, and so on. In a case in 1794, Lewis and Rucker, Lord Mansfield drew on the expertise of a special jury to enable him to fashion principles of insurance law. As he explained it in his judgment in the case, the jury understood the question very well and knew more about the subject of it than anyone else present, and formed their judgment from their own notions and experience without much assistance from anything else that passed. Now, that experience drawing on the market helped Lord Mansfield, in the dawn of our modern commercial age, fashion these laws, and it ensured that we used practical experience together with his immense learning to shape law that was, although based in principle, was immensely practicable. Now, today, even if the judges had time to have jurors to discourse, and Lord Mansfield certainly had his jurors to dinner, this is something that I think a modern judge can simply not do. We've got to find a new means of the judges being kept absolutely abreast with commercial change. And what we've done in London, and what we did at the announcement, prior to the announcement and operation of the financial list, was to call upon an expert independent body established by the Bank of England, the Financial Markets Law Committee. Every year they provide us with a seminars on new developments in the law of finance. And before the launching of the financial list, they provided an entire day seminar to make certain that the judges were absolutely up to date in the latest imaginative musings of bankers or others. And it has been immensely successful. We think that this is something that needs looking at elsewhere in the world, is to how do you make certain that people are that judges are up to date. So when they have advocates talking to them about the principle in the way in which I've described, they can actually draw upon their own knowledge. Dinner with you all might be very agreeable, but I don't think that that is something that's acceptable. You have to look, as we've tried to look in London, for a method of bringing matters up to date. The second thing that I wanted to discuss under this heading was innovation of trying to answer a market's needs in a different way, and that is determining unresolved market issues. Now, if the courts are to perform what I consider their vital function, and where they have an enormous advantage over arbitration, and that is developing the law and making that law public. And we were asked by the market if we would look at a market test case scheme. We said yes, and the aim of that scheme is to provide a procedure for the resolution of market issues in which there is no immediately relevant authoritative English law guidance provided, and then we will provide that guidance through an open, transparent court process. Enables parties to bring proceedings where there is no present cause of action before the court to seek declaratory relief to answer what the market needs to know about how a particular issue will work out. And its origins lay in the very difficult problems that the financial markets raised in the possible eventuality of an exit from the euro of Greece. But it was also engendered by many other events of a similar kind, where there were different views and people needed to know actually what the answer was with great rapidity. Now, we hope that this will work. It is certainly innovative, and we've built in one further innovative procedure. We've decided to revive the old two-judge court, that in certain cases where really authoritative guidance is needed very urgently, a court may sit with two judges, one as a judge of the court and one as a judge of the Court of Appeal. We hope that that will provide, in a really urgent case, proper authoritative guidance where there will be a way in which we answer a market's question and the market can get on in that way. Now, I've taken those four topics, the duty of the judges to lead, but actually to take heed and to be motivated by the market, to look at the kind of people we employ, to look at the product, the way in which we do it, the process, and also to concentrate upon the high quality justice that we need and how we innovate to make certain that we keep that end product. But I do think that we need to look further. And I think what we have no doubt in London is that this is now a problem that stretches across the globe. It seems to us that as in England and Wales, so in each state, commercial courts now have their own independent status. Judges have duties, and in particular a duty to provide to the markets the dispute resolution that they need, but also a duty to develop the law, a function judges can perform, but which arbitrators cannot. And it seems to me, therefore, that in our interconnected global village, commercial courts must have a similar role in seeing what they can do to ensure global prosperity, to strengthen the rule of law in many respects by looking at the matter not simply within their nation state, but to looking at it across the world. Now there is, of course, an element of competition between commercial courts. It would be wrong to deny that. Occasionally, and very subtly, it is suggested by a particular court may have slight advantages over others. But although these courts are in a sense competitive, judges have that wider duty to which I have referred. And it therefore seems to me that the judges of these courts, or those responsible for them, the Chief Justices of particular jurisdictions, must do what we can to see how we can work together to ensure not only that we innovate across the world in a consistent manner, but what we can do to make certain that the rule of law is upheld internationally. And I believe that we can do such a thing without in any way or undermining our competitiveness or our independence. For as we all know, central bankers set about their duties to maintain international financial stability and growth without in any way impairing the competition and the fierce competition that exists between nations. Now this is a huge task, and as a small first step in this direction, I just over the recent vacation and with the full support of the Senior Judiciary of England and Wales, I wrote to Chief Justices or others responsible for other commercial courts across the world to suggest we establish a forum for commercial courts. The objective is to build on and develop a more systematic approach to providing a common approach to the resolution of disputes, and as important, to the development of the law to keep pace with the way in which our global village is developing. And I think that if we're able to start to develop more structured links, share best practices, consider problematic areas and novel developments, and build on the mutual confidence so important to the recognition of judgments of other courts, and engage constructively with our court users, we will be very much better able to realise the potential to which I referred at the outset and ensure that the prosperity and good order of the digital village is enhanced. And to this proposal I've had a very enthusiastic response. And the way in which we, I think, intend to take this forward is to have a first symposia organised within the course of the next 18 months. There are huge topics to choose from. For example, cross-border enforcement, something which the Chief Justice spoke about in his address to you before I spoke. The best use of IT, how can we not each of us invent the same wheel all over again? How do we deal with topical issues in arbitration? How do we enhance international coordination? And in the light of recent experience, how can we best respond to international financial crises and their aftermath? Having raised this with other Chief Justice, I've asked Mr. Justice Blair, the judge in charge of the Commercial Court, to set about this detailed organisation with his customary vigour. I'm not looking at a symposium as a talking shop. I don't believe in them. But what I do believe in is something that will deliver concrete benefits, not merely to the lawyers of you here present tonight, but more importantly to those who operate our financial and commercial markets and really bring concrete benefits. I am optimistic we will get somewhere, and I am optimistic particularly in the areas that are so important: the development of the law, the relationship to arbitration and enforcement, that we can make such progress. The world has come together, and as I've indicated, we now live in a transformed and interconnected world. We're developing very rapidly, and our courts simply cannot be left behind. And they will be left behind unless we have a clear strategic approach based on some of the ideas I put forward tonight. It seems to me that that strategic overview is so important to ensuring a real commitment across the globe to the rule of law in commercial matters and to the development of our law. I'm convinced we will be able to do this. I'm sure I will be able to count on the enormous support of the court here in Dubai, as well as elsewhere. We have a very interesting and very considerable challenge. Judges sometimes can be bold, and boldness is required of us, and of course we could not do that without the support of the legal profession, and if I may say so, the administration and the market users behind us all. Thank you very much.